will discuss about the bail under section 376 IPC. Then good morning to all of you friends who have joined till today, till date. And we will further update what is the bail, then what types of the bail, and then we will discuss about what is the definition of the rape 375 and what are the punishment under 376 IPC and what are the judgments and how we will proceed. Basically, our entire discussion today would be on the false pretext of the marriage. There are the prevailing trend in the society nowadays. There are the most of the cases are coming that there is a false pretext of the marriage. On the false insurance of the marriage, the girls are being harassed, humiliated. Therefore, we want to discuss on this issue. And certainly, before discussing this issue, we will understand what is the definitions and what types of the bail and all those things. Just I will share the PPT with all of you. First of all, we have to understand there are certain definitions. It is visible to all of you?
Yes, sir.
Yes, sir.
Yes, sir.
Thank you. Our session is going to be some, we will have a one-to-one discussions as well, because there should be no any one-way communications. And you should all participate in this because this is the very interesting topic. Bail in the matter of 376 IPC. So first of all, we have to understand the basic things, that what is the bail and what types of the bail. Bail is a judicial release of an accused charged with a certain offense by imposing certain restrictions on him and compelling him to remain with the jurisdiction of the court. The word bail is not defined under the Code of Criminal Procedure. Has not been defined under Code of Criminal Procedure CRPC. Only the term bailable offense and non-bailable offense has been defined under Section 2A of the Criminal Procedure Code. Then normally people, the general people understand that what is the bail? Bail means you are free and your case is over. No, the bail is a judicial release of an accused person charged with a certain offenses by imposing certain restrictions on him and compelling him to remain with the jurisdiction of the court. Even if you granted the bail, you cannot go anywhere. You have to be regularly attend the court hearing on every date. Once you are not attending the date on any date and missing any date, then the court compel you that yes, you have to appear before the court. You cannot free from the justice. Of course, there is a bail is granted. You are free from jail, but you are not free from the cases. There are the two types of the offenses. There are the bailable offenses and one is the non-bailable offenses. Then what is the difference between bailable and non-bailable offenses? According to Section 2 of the CRPC, bailable offense means offense that is classified as bailable in the first schedule of the code or which is classified as bailable under any other law. In the CRPC, we'll go through, there is a first schedule. In the first schedule, there are the certain offenses are classified as the bailable offenses and non-bailable offenses. These offenses, bailable offenses are those offenses which are classified under first schedule. And once the offense is bailable, then certainly we will get a bail. We will discuss later on. And the non-bailable offenses, an offense not mentioned as bailable under the first schedule of the CRPC or any other law is considered as a non-bailable offenses. The bailable offense is defined under Section 2A of the CRPC, but non-bailable offense is not defined. This is the only definition is the offense which is not bailable, which is not classified as in the first schedule of the bailable, then all those offenses are non-bailable. So that's what is the basic difference between the bailable and non-bailable offenses. Bailable offense 436 CRPC discussed about the bailable offense, and 437 and 439 CRPC discussed about the non-bailable offenses. Bailable offenses, it means you are the right to have a bail. So no one can deny your bail. It is a bail is a matter of right under section 436 bailable offenses. But in the non-bailable offenses, bail is a matter of the court discretion, because you cannot say this is my right and you have to grant the bail. In the non-bailable offenses, no. It is a discretion of the court that court may grant you bail on the certain facts and circumstances of the case, and then the court may decline your bail in the non-bailable offenses. But in the cases of the bailable offenses, yes, court has to grant the bail. Section 436 of the CRPC lays down the provision for the bail in the bailable offenses, and section 437 and 439 of the CRPC lays down the provision for the bail in the non-bailable offenses. We will discuss in detail what is the difference between 437 and 439. Bailable offenses are considered less serious in nature. Of course, once you are granting the bail, it is less serious in nature, and non-bailable offenses are more serious in nature. They are the heinous crimes. Generally punishable with imprisonment are not less than 3 years. Generally punishable with imprisonment for 3 years or more. These bailable offenses are punishable with imprisonment for less than 3 years, and non-bailable offenses are punishable with imprisonment for more than 3 years. Then we will discuss about the types of the bail. What are the types of the bail? That is the regular bail. The court ordered the release of the person who is under arrest. The regular bail, you move the bail as a regular bail only when the person has been arrested by the police officials. The court ordered the release of the person who is under arrest from the police custody after paying the amount as a bail money, as accused can apply for regular bail under section 437 and 439 of the CRPC. What is the difference between 437 and 439? 437 offenses are triable by the magistrate, and 439 are offenses which is triable by the session court. Once you are moving an application under section 437, then that application has to be before the magistrate. It is triable by magistrate. And once you are moving an application under 439, then it has to be before the Honorable Session Court or High Court or the Supreme Court. You cannot go under 437 before the Session Court. This is the difference between 437 and 439. What is the interim bail? This is the direct order by the court to provide temporary and short-term bail to the accused until his regular or anticipatory bail application is pending before the court. Interim bail means you will granted a short and temporary bail. Means unless and until there is a regular bail or anticipatory bail is granted, meanwhile, you will grant an interim bail, interim protection, that yes, like as in the case of, you can take an example of the Honorable Chief Minister Kejriwal case, that he has granted interim bail. Means there are a certain period of time you are free from the, you are out of the jail. He was in the out of jail approximately 12 or 13 days, whatever the time period. But to campaign that particular election, then again he go to the jail. So this is the interim bail. It means for the certain time period, there are certain time periods granted by the court that yes, you are out of the jail for certain period. Then again, if the regular bail or anticipatory bail is not granted, then again you have to go to the jail. Anticipatory bail. A person under apprehension of arrest for the non-bailable offence may apply for the anticipatory bail to the High Court or Court of the Session under section 438 CRPC. Anticipatory bail, you have to, once you are moving an application under 438, section is very important. Under section 438 of the CRPC, you can go for the anticipatory bail. You cannot go under section 439 and 437 or 436. You have, this is the very particular, that once you are moving an application, then you have to mention the section 438 of the CRPC. And this is one of the another important issue, that once you are moving the anticipatory bail only go to the either session court or to the High Court. Never, you never go to the magistrate for anticipatory bail. Anticipatory bail is only granted by the either session court or Honorable High Court or Honorable Supreme Court. So this is the very important things: regular bail, interim bail, anticipatory bail. Section is also important. 436, 437, 438, and 439. So you all are remember about it. And this is a very interesting case. What is the default bill? This is another type of the bill. Are all of you are aware about the default bill?
No, sir.
Yes, any one of you?
No, sir, I'm not aware about this.
Any of you who is joined this are aware about the default bill?
As per
Yes.
as per my understanding, the default bill is when in the case triable by under before magistrate, it is after 60 days of arrest, and if it is triable by session court, after 90 days of the initial period, when arrest is, then we are liable for the or eligible for a default.
No. Up to the mark, you are correct. Anyone, please? Yes. And my learned friend discussed about 60 days and 90 days. Are you aware when 60 days will be calculated and 90 days will be calculated from which date?
So from date of the arrest.
Anyone, please?
Link charge sheet.
Okay, no, then we will discuss.
These sections starts at 436, 437, 6 clause.
No, unless we will discuss. What is the default bill? And when the default bill occurs? The section, according to section 167 of the Code of Criminal Procedure. This default bill discussed under section 167 of the CRPC. When a person is arrested and investigation cannot be completed within 24 hours, they must be presented before the magistrate. The thing is, there is a specific provision in the CRPC that once you are arresting the persons and you have to present that person before the learned magistrate within 24 hours of his arrest. Once you are not presenting that person within 24 hours of arrest, then he is entitled for the default bill. Further, we will discuss. The magistrate can then authorize their detention for a maximum period of the 15 days. Typically, this detention period is extended by an additional 15 days to allow the police or investigating agency to complete their investigation. However, section 167 subsection 2, this talks about the CRPC specifies that in cases involving offences punishable by death, life imprisonment, or imprisonment of at least 10 years, the detention period cannot exceed 90 days. There are the two types of the offences that the death penalty is 10 years or more. Then in that particular case, there is a 90 days. You have to file the police officers has to file the charge sheet within 90 days. And the offences is less than 10 years. Then there is another classification that yes, the charge sheet has to be filed within 60 days. There are the two types of the offences, which is more than 10 years and less than 10 years. Then there is a certain time period has been granted specific by this code that yes, you have to file the charge sheet within 60 days and 90 days. For further offences, the limit is 60 days. There are two types of offences. Once the police has arrested you, then it is a duty of the police from the date of the arrest, within 24 hours from the arrest, you have to produce that person before the learned magistrate. Once you are not doing so, then he is entitled for the bail. Another case that once the police person has arrested that person and produced before the magistrate within 24 hours, then if the offense is like that, the charge sheet has to be filed within 60 days. And another offense is that the charge sheet has to be filed within 90 days. Then 60 days and 90 days calculated from which date? This is a very important issue. And there are the different judgments by the Honorable Supreme Court that whether 60 days will be calculated from the date of the remand or from the date of the arrest. This question was also arises. Then the Honorable Supreme Court is very clear on this issue that 60 days will be calculated from the date of the remand. Suppose if the person is being produced before the learned magistrate and learned magistrate send him into the jail, the day at which the learned magistrate has sent him the jail, that from that day 60 days will be calculated, and from that day 90 days will be calculated. There are the controversial judgments takes place by the Honorable Supreme Court in the Chaganji Satyanarayan versus State of Andhra Pradesh. In this judgment, this is the landmark judgment. Thus, in view of the matter, that is a construing provision either in the conjunction with the subsection 2 of section 166 or as independent paragraph, we find that the total period of 90 days under clause 1 and total period of 60 days under clause 2 has to be calculated only from the date of remand and not from the date of arrest. This is very clear that the 90 days or 60 days will be calculated from the date of remand. One of my learned friend has especially discussed that it has to be from the date of arrest. No, it is from the date of remand. Once the judicial magistrate send you in the jail after producing, then 60 days will be calculated from the date of remand, not from the date of arrest. So this is very clear. Another question arises that whether the date of remand will be included in that 60 days or 90 days or not, and the date of the filing of charge sheet will be included or not. Then one of the judgment, this is the judgment of the Chaganti Satyanarayan, in which the court says calculated from the date of remand means date of remand has to be included in 60 days. Another judgment from Roshan, in which Honorable Supreme Court says that date of remand has to be excluded, means that particular day has to be excluded. But there are the controversy arises because these two judgments are the Honorable Supreme Court double bench judgment. Then the matter, then there is a controversy from the different high courts. Some high courts say yes, it has to be included. Some high courts say no, it should not be included. And at the date in which the charge sheet has been filed, that has to be included. That is very clear. 60 days that has to be included. That is no exclusion. The question was only exclusion of the date of the remand. Then this matter has to refer to the higher branch. ED versus Kapil Wadhawan. Enforcement Director versus Kapil Wadhawan. This matter has to refer for the higher branch. 3-bench judgment. The Supreme Court referred this issue to the larger bench and the same is decided on 27th March 2023. Latest, in which the para number 50, kindly go through this judgment. The para number 50 of this judgment, we therefore declare that the stipulated 60 or 90 days remand period under section 167 ought to be computed from the date when the magistrate authorizes remand. Means there are the some controversial judgment that day has to be included or not included. Then this is the very clear by the Honorable Supreme Court that yes, whatever the date of the remand, that has to be included in 60 days, no exclusion at all. If the first day of the remand is excluded, and this is the argument that if the first day of the remand is excluded, the remand period, as we noticed, will extend beyond the permitted 60 or 90 days period, resulting in unauthorized detention beyond the period in which there's under section 167 CRPC. Suppose if the date of remand is that particular day, this is the, in this judgment, Honorable Supreme Court is very clear, date is particular mentioned. Suppose if it is today is 8th June and your 60 days expire on the 7th June, then the charge sheet has to be filed on that particular day only, 7th. If it is filed on the 8th, then you are obviously default bail is granted to you. In the default bail, there is no discretion to the court. He has to be granted. resulting in authority detention beyond the period of injunction under section 167. So, probably I think this 167 kindly go through the judgment of the enforcement director versus Kapil Adhan. That is very clear by the Honorable Supreme Court. In cases where charge sheet, the final report is filed on or after the 61st, 91st day, the accused in our considered opinion would be entitled to default bail. In other words, the very moment the stipulated 60 and 90 days remand period expires, an infeasible right to default bail accrues to the accused. Means 60 or 90 days once the over, then he is entitled for the default bail. It is clear to all of you, my learned friends. Is there any question and query? Then we will discuss, then we will go ahead. Yes, please. Am I audible?
Yes, sir.
Am I audible to all of you or not?
Yes, sir. Yes,
Yes,
sir.
sir.
Yes, sir.
It
Yes,
is clear. It is clear to all of you. Default bail.
Yes, sir.
At least say something once you are discussing. You are here to discuss.
Sir, it is clear now.
Okay. Then you can go ahead further. The another bail is the transit anticipatory bail. Probably all of you aware about the transit bail. देखिए मोदी के कार्यकाल को बंद कीजिए प्लीज. जो भी हमारे साथी टीवी चला रहे हो ये म्यूट कर लीजिए प्लीज.
म्यूट कर
Are you
दिया.
aware about the transit bail? Anyone of you? हमारे इतने विद्वान साथी बैठे हुए हैं, प्लीज बताइए. Are you aware not about transit bail?
Yes, sir. When the accused in another state and police has to arrest from another state, then in that case we have to take transit bail of that particular jurisdictional area magistrate. Like in
Yes.
many of cases in UP, they have taken the transit bail and वो गाड़ी जो उन्होंने पलटाई वो सारी ट्रांजिट बेल में ही है.
जी 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 प्लीज प्लीज दीपक जी.
Right.
गुड गुड वेरी गुड वेरी गुड. बहुत दीपक जी ने बहुत अच्छा बताया ट्रांजिट बेल. तो ट्रांजिट बेल का मतलब ही यही होता है कि इफ द ट्रांजिट बेल मींस वंस FIR has been registered in the another state and police came from the another state to arrest you, then you can move on that particular jurisdictions of the learned magistrate that yes, there is apprehension of the arrest and I may be arrested by the another state police. Therefore, please grant me for certain period of the time so that I can manage and I can appear before that particular state learned magistrate and seek bail. Therefore, there are the certain protection has been granted for the certain period of time. Transit anticipatory bail. Recently, the Supreme Court of India, in the case of the Priya Indoria versus State of Karnataka and others 223, ruled that Session Court or the High Court in the state can grant transit anticipatory bail to the accused, though the first information report is registered outside their jurisdictions. So this is the only transit bail is applicable only when then the FIR has been registered in the somewhere another states or there is apprehension of arrest. Then you can move on the transit bail that yes, there should be certain protection may be granted for certain period of the time so that I can go to that particular state and look into the matter, what is the case is, then I can move the appropriate application before that particular magistrate. Supreme Court authorizes the constitutional imperative of protecting citizen rights to life and personal liberty as enshrined in Article 21 of the Constitution of India. The Supreme Court is the concept of the transit anticipatory bail in the case of the state of Assam versus Brujen Gogol in the 1998. This type of the bail provides equitable and interim relief, particularly for individuals residing in the different states. This is important. This type of the bail provides equitable and interim relief, particularly for individuals residing in the different states. Holds that High Court or Session Court should grant transit anticipatory bail in the form of the interim protection under Section 438 of the Code of the Criminal Procedure 1973. in the interest of the justice concerning FIR registered outside the territorial jurisdictions of the state court. Once you are going for the transit bail, that you have to move a bail under section 438 of the CRPC, like as an anticipatory bail. So this is the anticipation that he may be arrested, then you have to move the transit bail as in under section 438. Then we will discuss about what is the definition of the rape. 375 talks about the definition of the rape, and 376 talks about the punishment. The punishment is 10 years or maybe the life imprisonment. Whoever, except in cases provided in subsection 2, commits rape shall be punishable with rigorous imprisonment, either descriptions for a term which shall not be less than 10 years, but which may extend to imprisonment of life and shall also be liable to fine. The rape is one of the most heinous crimes as considered under our code of the civil procedure, and most rigorous imprisonment is there. There is a definition of the rape that defines under 375, and mostly our discussions for today that we will these are the man is said committed to the rape. If he doing all those things, you can go through. Under the circumstances falling under any of the following 7 descriptions. First, if you are doing something against her will, then it is considered rape without her consent. Thirdly, with her consent, when her consent has been obtained by putting her or any person in whom she is interested in fear of the death or hurt, you are putting pressure and taking the consent forcibly. This is also constitute an rape. Fourthly, with her consent, when the man knows. This is the important. We entire discussions takes place on this issue only. With her consent, when the man knows that he is not her husband and that her consent is given because she believes that he is another man to whom she is or believes herself to be lawfully married. This provision is very important, only focusing on this issue, because this is the one of the important issue, that there is a false pretext of the marriage. Nowadays, there is a prevailing cases before the Honorable High Court, Supreme Court, and all district courts, that there is a false pretext of the marriage, and he has promised me to marry me after some period of the time, because nowadays there is a era is a very advanced stage, very advanced age we are living, and people are being more modern. Then there are the certain living relation concept is also came into the picture. So people are living together for more than 4, 5, 6 years or 2 years, and they are enjoying the company. And later on, they file the case registered under section 376 IPC, because that the allegation is in the most of the cases, I will discuss with the judgment. In the most of the cases, that the allegation that yes, there is a false pretext of the marriage. He has promised me to get me married, but after some time he has not getting married. Therefore, the FIR has to be registered against him. So entire discussions is based on this with her consent. Even though there is a consent of that particular lady, when the man knows that he is not her husband and that her consent is given because she believes that he is another man to whom she believes herself to be lawfully married, means she will get married later on. Fifthly, with her consent, when at the time of the giving such consent by reason of the unsoundness of mind or intoxication or the administration by him personally or through another of the any stupefying or unwholesomeness substance, she is unable to understand the nature and consequence of that to which she given consent. Means he is not the sound state of the mind, and giving the consent is also covered under, or you are intoxicating, means you have given certain intoxicating means आपने इनको कुछ ऐसे पिला दिया जिससे वो बेहोश हो गई, and then you committed something, then it is also constitute an rape. With or without her consent, when she is under 18 years of the age. This is also important. Once, even though her consent was there, but when she is under 18 years of the age. Once she is, any girl who is under 18 years of the age, it should be very cautious, because I am also educating to the people that once you are entering into some friendship or relationship, then you should understand that even once the girl is less than 18 years of the age, then her consent is no value in the eyes of the law. Even though she is consented, but her consent is no value in the eyes of law. Her consent is not consent. With or without her consent, even though she is consented to have a relationship with you or sexual relationship with you, but you have committed an offense of the rape, with or without her consent, when she is under 18 years of the age. Age is very important. All the boys should understand this is the very important issue. When she is unable to communicate consent, then also this is some sort of offense. So probably this all about we have discussed that what is the rape, what types of the rape, and what are the offenses. And if there is any questions, queries on this issue, then certainly we will discuss. Otherwise, you will move further. Yes. Anyone, please? कोई इशू है, कोई कुछ बात है तो वो एक बार हम डिस्कस करते हैं. Then we will go ahead. We will discuss the judgments. Please. किसी को कुछ पूछना है, कोई डाउट है, then we will discuss.
सर ट्रांजिशन बेल जो है वो फाइल में कहाँ करेंगे, ये क्लियर नहीं हो पाया.
जैसे ट्रांजिशन बेल आप फाइल वहां करेंगे जहां आप रहते हैं. सपोज आप मान लीजिए दिल्ली में रहते हैं, आप जो है पटेल नगर में रह रहे हैं और आपका जो है यूपी में FIR रजिस्टर हो चुकी है. यूपी की पुलिस आपको यहाँ आ रही है, तो आप जहाँ रहते हैं वहां के कंसर्न मजिस्ट्रेट को अप्रोच करेंगे.
सर मजिस्ट्रेट या सेशन जो भी होगा, करेक्ट.
जो जैसे मान लीजिए अगर जो आपका ऑफेंस है ट्राइबल बाई मजिस्ट्रेट है, तो बहुत सी बात है मजिस्ट्रेट को अप्रोच करेंगे. ट्राइबल बाई सेशन है तो सेशन को अप्रोच करेंगे. लेकिन नहीं सॉरी, ये क्योंकि ये एंटीसिपेटरी बेल का ही होता है, 438 में जाता है तो बाई सेशन ही होगा, ट्राइबल बाई सेशन ही होगा, क्योंकि ये अंडर सेक्शन 438 में ही जो है आपकी ट्रांजिट बेल लगती है. तो जो आपका कंसर्न, जैसे पटेल नगर का जो जुडिक्शन जो है 30 सारी पड़ता है, तो आप 30 सारी कोर्ट जाएंगे. और चले फिर आगे बढ़े. जी, विथ योर कंसेंट. कोई बोल ही नहीं रहा है.
Yes, sir, it is very clear. You can proceed further.
यस यस, थैंक यू. देखिए अब हम इसमें हम डिस्कस करते हैं कि भाई अब जैसे मान लीजिए कोई, अगर हम जजमेंट पे डिस्कस करते हैं, सबसे पहले हम अगर वंस द पर्सन FIR हैज बीन रजिस्टर्ड, और FIR अगर रजिस्टर हो गई है तो फिर उसके लिए जो है, क्योंकि देयर इज एप्रीहेंशन ऑफ अरेस्ट, सबसे पहले तो हम एंटीसिपेटरी बेल में ही जाते हैं. सबसे पहले वी विल डिस्कस अबाउट द एंटीसिपेटरी बेल. एंटीसिपेटरी बेल में सबसे पहले हम डिस्कस करते हैं लेटेस्ट जजमेंट ऑफ द ऑनरेबल हाई कोर्ट 2023. in the High Court of Delhi at New Delhi, bail application so and so, Saurabh Babbar versus State of Government of City of Delhi. नॉर्मली इस ऐसे केसेस में जो है लड़कियों के नाम छिपा लिए जाते हैं, उनका नाम XYZ व्हाटएवर कहा जाता है, उनके नाम नहीं लिया जाता है. इस मैटर में जो है एंटीसिपेटरी बेल मूव हुई है और ऑनरेबल हाई कोर्ट ने एंटीसिपेटरी बेल ग्रांट भी की थी. देखिए, ईच एंड एवरी फैक्ट एंड सर्कमस्टांसेस ऑफ द केस ऑफ द डिफरेंट. ऐसा देयर इज नो स्ट्रेट जैकेट फार्मूला की there should be some grant anticipatory bail. Each case have their different facts and circumstances. This is the discretionary power vested with the honorable courts, whether bail should be granted to you or not granted to you. So then it is depend upon the fact and circumstances of the case. So every facts, there is no straight jacket formula. Every facts, every circumstances are different. Main plank of the argument of the learned counsel for the petitioner. This is the case decided by the Honorable High Court of Delhi, 2023, latest. Main plank of the argument of the learned counsel for the petitioner is that the prosecutor is a married woman, albeit divorce petition is pending between her and her husband. Petitioner is also married and blessed with 2 children. Since the prosecutrix is legally married, she could not have been induced into the alleged offense on the false pretext of the marriage. इस पर्टिकुलर केस में ये हुआ था कि इसमें जो है जो कंप्लेनेंट है, जो लड़की थी वो भी शादीशुदा थी, जो लड़का था वो भी शादीशुदा था, लेकिन लड़की ने जो है इसमें जो है अपना डाइवोर्स पिटीशन फाइल कर रखा था, लेकिन डाइवोर्स हुआ नहीं था। ऐसे केसेस में जहाँ पे अगर ऑलरेडी कोई मैरिड है और जहाँ पे जो है वो डाइवोर्स नहीं हुआ है, the lady which is already married and the divorce has doesn't takes place, means unless and until you have a degree of the divorce, as per the Hindu law, you are not entitled to marry with someone else. So अगर कोई ऐसा आप लोगों के पास केस आता है जिसमें ऐसा है, तो फर्स्ट ऑफ ऑल यू हैव टू लुक इनटू दैट कि उसका डाइवोर्स हुआ है या नहीं हुआ है। अगर डाइवोर्स नहीं हुआ है तो वो लीगली इंटाइटल्ड नहीं है किसी से शादी करने के लिए। अगर कोई भी उसके साथ अगर सेक्सुअल रिलेशन बनाता है या वो लड़की किसी के साथ रहती है, अगर वो लीगली डाइवोर्स नहीं है, समटाइम्स ऐसा भी होता है बहुत सारे केसेस में, कई लोग जैसे गांव में शादी किए, गांव में शादी करने के बाद वहां अगर नहीं बनती है तो वहां उसको छोड़ करके घर आ जाते हैं। लेकिन आज भी ऐसा है कि गांव में कई लोग जो है छोड़ के चले आते हैं, लेकिन वहां पर डाइवोर्स नहीं लेते हैं। या फिर शहर में भी कह सकते हैं कि भाई दोनों लोगों की नहीं बन पा रही तो वो उनका घर छोड़ के आगे साल 2 साल 5 साल 7 साल वो वहां पे गए ही नहीं, मतलब लीगल प्रोसीडिंग नहीं हुई, लेकिन वहां नहीं गई तो वो अपने आप को मान के चलती हैं कि भाई मैं उससे जो है मेरा रिलेशन खत्म है, लेकिन लीगली वो रिलेशन खत्म नहीं होते अनलेस एंड अनटिल शी आर ही बीइंग हैव ए डिग्री ऑफ डाइवोर्स। ऐसी कोई लेडी जो किसी के साथ रहती हैं, उनके साथ रिलेशनशिप बनाती हैं और बाद में उनके ऊपर केस कर देती हैं कि भाई आप मेरे से शादी करने का वादा किए थे और आपने मेरे से शादी नहीं किया, ऐसे केसेस में जो है कोर्ट का मानना यह है कि अनलेस एंड अनटिल शी इज हैविंग द डिग्री ऑफ द डाइवोर्स, शी कैन नॉट मेक एन एलिगेशंस दैट देयर इज ए फॉल्स प्रिटेक्स्ट ऑफ द मैरिज। Prosecutrix in married domain, albeit divorce petition is pending between her and her husband. Petitioner is also married and blessed with 2 children. Since the prosecutrix is legally married, she could not have been induced into the alleged offense of the false pretext of the marriage. In this case, it is also there are the certain judgments has been discussed by the Honorable High Court. In the one of the judgment is Raj Dulari Supra will discuss later on, wherein this court has held that when a victim herself is not legally eligible to marry someone else due to her existing marriage to another partner, she cannot claim to have been induced into the sexual relationship under false pretext of the marriage। जो कि हमने आपको जो है जब मैरिज की डिफिनीशन सॉरी रेप की जो अंडर सेक्शन 375 में डिफिनीशन में बता रहा था, उसमें फॉल्स प्रिटेक्स्ट ऑफ द मैरिज था, एक्सप्लेनेशन 4 था, उसमें जो है ये लिखा गया है कि अगर कंसेंट भी लेते हैं लेकिन उसका जो वो बाद में मान की चलती कंसेंट इसी परिस्थितियों में दे रही है कि भाई मैं जो है इनसे बाद में शादी करूंगा, ऐसे में अगर कंसेंट दे भी देती हैं अगर, लेकिन अगर वो मैरिड ऑलरेडी मैरिड हैं तो उनका जो है ये नहीं किया जाएगा कि नहीं जो है इन्होंने मेरे को धोखा दिया, ऐसा नहीं कर सकते। This court has held that when the victim herself is not legally eligible to marry, because unless and until she gets divorced from the from her husband, she is not legally eligible to marry someone else as per the law. बाकी तो जो हमारे कस्टम ट्रेडिशन है जो भी चलते हैं, बट एज पर लॉ शी इज नॉट इंटाइटल्ड टू गेट मैरिड विद समवन एल्स अनलेस अनटिल शी डाइवोर्स someone else due to the existing marriage of another partner. She cannot claim to have been induced in sexual relationship under the false pretext of the marriage. Thus, the protection and remedies available under section 376 of the IPC cannot be extended to a victim who was not legally entitled to marry the person with whom she was in the sexual relationship. In this case, that the Honorable High Court, in the light of the above, it is directed that in the event of the arrest of the petitioner in FIR number so and so, petitioner will be released on bail on his furnishing the personal bond in the sum of so and so. ऐसे केसेस में जो है बेल ग्रांट हो गई थी। अब दूसरा केस हम लोग डिस्कस करते हैं। रोहित चौहान इट इज आल्सो डिसाइडेड बाय द ऑनरेबल हाई कोर्ट। इसमें एंटिसिपेटरी बेल के लिए गए थे 376 के एलिगेशन से प्रेजेंट एप्लीकेशन फाइल seeking anticipatory bail of the offense punishable and so held allegation applicant had physical relation with the prosecutors for long period of time on false pretext of the marriage. means the person who is having the relationship, suppose जैसे मैंने आपको पहले ही बताया कि आजकल का जो लेटेस्ट ट्रेंड चल रहा है कि लोग पहले शादी नहीं करते हैं, लोग स्टूडेंट भी रहते हैं, फिर भी अपने आप जो है वो लिविंग रिलेशन में रहते हैं, 2 साल 3 साल 4 साल जैसे पढ़ाई कर रहे हैं, तो सोचते हैं कि एक साथ ही रह लेते हैं। एक साथ रहने के बाद जो है उसके बाद अगर बाद में शादी नहीं करते हैं, तो ऐसे केसेस के लिए ये है कि इसमें ये कहा गया था कि एज पर द एलिगेशन एप्लीकेंट हैज फिजिकल रिलेशनशिप विद द प्रोसिक्यूटर फॉर लॉन्ग पीरियड ऑफ द टाइम ऑन फॉल्स प्रीटेक्स्ट ऑफ द मैरिज। मैं आपसे जो है जैसे मान लिया अगर मैं कहीं सेटल हो जाता हूँ, क्योंकि आज की डेट में जो है सेटल होने की भी एक बहुत बड़ी समस्या है, क्योंकि हार्डली टेक सम टाइम। कई बार सेटलमेंट होते होते 30 साल 32 साल 35 साल की उम्र हो जाती है, तो लोग सोचते हैं कि भाई जो यंग जनरेशन सोच रही है कि चलो ठीक है, वाई शुड आई गेट मैरिड एंड वाई शुड आई टेक द रिस्पॉन्सिबिलिटी। लड़कियां भी रिस्पॉन्सिबिलिटी लेना नहीं चाहती, लड़के भी नहीं लेना चाहते हैं। ऐसे केसेस के लिए जो है और दे इंटर टू द फिजिकल रिलेशनशिप लॉन्ग पीरियड ऑफ टाइम, प्रोसिक्यूटर्स डिड नॉट अपीयर टू बी द सच। ऐसे केसेस में कोर्ट का कहना है कि प्रोसिक्यूटर्स डिड नॉट अपीयर टू सच ए वल्नरेबल लेडी दैट शी वुड नॉट रेज her voice on being mentally exploited over such a long period of the time. Marriage between the complainant applicant has taken place and both parties did not dispute this fact. Therefore, state circumstance by itself entitled the applicant to grant anticipatory bail. इसका फैक्ट्स देखिए क्या था। फैक्ट्स देखने के बाद जो है it will be very clear. As per the complainant who is the present in the court, the petitioner took the complainant to his house in Rishinagar, Rani Bhagon on so on the pretext of introducing her to her mother. But since there was no one present in his house, he possibly had physical relationship with her. It is also a case of the prosecutor that when she tried to shout, then the petitioner taunted her that he would kill her and defame her, and at the same time he asked her not to worry as he loved her and would marry her. But if in the case she discloses the said relationship to anyone, then the petitioner would harm himself physically. It is also the case of the prosecutor. Petitioner also gave certain pills to her so that she would not conceive. It is further alleged by the prosecutors that the petitioner also threatened to kill her family members and to show her obscene videos to her parents and upload the same on the YouTube if she dared to refuse to maintain physical relationship with him. It is also the case of the prosecutors that on 9th July 2012, the petitioner administered some drug in her cold drinks, which she drank and again was forced to have physical relationship with so-and-so. It is also case of the prosecuting then on dated so-and-so. She filed a complaint at police station Shalimar Bagh, which was later transferred to the police station Rani Bagh. But the prisoner and his family members were called by the police and they assurance that they will arrange the marriage of the petitioner with the complainant only if the complainant withdraws the said complaint. As per the complainant, the marriage has solemnized on so-and-so, dated so-and-so, where the family of the petitioner, his mother, so-and-so, Mercy Ponam, all those were present there. It is also the case of the prosecutors that after the solemnization of the said marriage, the petitioner did not take her to his house even for a day, and rather after 2 days of the marriage, the petitioner and his family member took the prosecutors R. Samaj Mandir, beat her and possibly took her signature on one paper by dissolving the said marriage. It is also the case of the prosecutors that after the marriage, the petitioner and his family members visited her locality several times and abused her besides creating nuisance outside the house. It is also a case of the prosecutors that her sister was also threatened whenever she used to go to the school. It is also a case of the prosecutors then so-and-so. She again made a complaint against the petitioner and his family members in the police station Shalimar Bagh, and when they were called by the police, they have demanded one flat and ₹20 lakh. The prosecutors wanted to live with them. Thereafter, a complaint was filed by the prosecutors with the crime against so-and-so. These all are the facts of the case. Once you will go to the facts of the case, then what is the judgment? Because it is not possible to go through the entire judgment in this 1 hour session. So kindly go through the judgment, just only giving a reference. What is the finding of the court? Undoubtedly, there is a manifold increase in the crime concerning rapes, but all the cases, rape cases which are filed have their own individual story and factual metrics. While most of the cases may be genuine, wherein the girl is a victim of this horrifying crime or has been forced, blackmailed, threatened to enter into the physical relationship with a male on the false pretext of the marriage with the sole intent to physically exploit the girl, but there may be the cases where both persons out of their own will and force develop a physical relationship. Many of the cases are being reported by those women who have, this is important, many of the cases are being reported by those women who have consensual physical relationship with a man But when the relationship breaks due to one or the other reason, the woman used the law as a weapon, or the court is using the word, the woman used the law as a weapon for vengeance and personal vendetta to extort money, and sometimes even to force the boy to get married to her. Out of the anger and frustrations, they tend to convert such consensual sex as an incident of the rape, defeating the very purpose of the provision. There is a clear demarcations between the rape and consensual sex. This is the very clear demarcation, the rape and consensual sex. And in the cases where such controversies are involved, the court must very cautiously examine the intention of both the individuals involved and to check if even the girl on the other hand is genuine or had malified motives. Cases like these not only make mockery of the sacred institution of the marriage, but also inflate the statistics of the rape cases, which further deprecates our own society. This is a very strong wording used by the court. In the facts of the present case, here is the complainant who appears to be quite an ultra-modern lady with an open outlook towards life, enjoying alcohol in the company of men, which is evident from the photographs placed on record, which have not been denied by the prosecutors present in the court. She doesn't appear to be a such vulnerable lady that she would not raise her voice on the being immensely exploited over such a long period of the time. If there is a delay in FIR, then this is one of the grounds for also taking the bail. As per the prosecutors, she has a physical relationship with the prisoner for the last more than 2.5 years, and it is not just a single act of the sharing physical intimacy, but the same continued for almost a long period of the 3 years. There lies a possibility that the prisoner might have then refused to marry prosecutors, and this refusal on the part of the prisoner gave a serious jolt to the prosecutors, who then, with the help of the police, solemnizes the marriage with him in the wee hours of the night when the prisoner was in his casual affairs. It is only that the complainant raised her voice for the first time and made allegations of the rape against the prisoner. It is an admitted case that the said marriage ultimately did not consummate, as the complainant was never brought to the matrimonial home, and the petitioner has already filed a civil suit to seek divorce. Decree of declaration for the declaring said marriage as null and void. Then in these cases, it is settled position of the law that every case has to deal with on the considering the facts of the present in light of the aforesaid discussion and the material on court. I'm inclined to grant anticipatory bail. Then the anticipatory bail was granted in this case. Another case we will quick look into the Jagdish Notial. This is also the judgment of the Honorable High Court, 2012. Briefly stated facts of the prosecution that so-and-so date, the complainant in one Gita, a permanent resident of Dehradun, filed a complaint in crime against woman self, New Delhi, against the present petitioner Jagdish Notial, working as a private secretary in the National Human Rights Commission. In the said complaint, the complainant leveled allegation that she was married to one Sushil Kumar in the year 1994, and from the said wedlock, she was blessed with a daughter who was born in so-and-so. Unfortunately, the husband of the complainant, Sushil Kumar, expired because her heart attack so-and-so. The present petitioner was friendly terms with the deceased husband of the complainant, and he started visiting the complainant. The present petitioner is alleged to have made a proposal of marriage to the complainant and stated that he was unmarried and he would take care of the complainant as well as his daughter. Believing the representation of the present petitioner, complainant is stated to have contracted marriage so-and-so in Buddhist temple Mandir Mark so-and-so near Birla Mandir. As per the Hindu law, photographs and necessary documentation in this regard completed. After the marriage so-and-so, the petitioner applied for the registration of marriage so-and-so, marriage registration office. He filled up the requisite forms and all those handwritings. It is alleged by the complainant that after the marriage, the petitioner cohabited with the complainant. It is stated in the complaint. Complainant learned that the present petitioner was already married to one Sunita and was living with her at the address mentioned in the memo of party. It is also stated by her that the petitioner was having 2 children from the said marriage. Because of these relations, the complainant confronted the petitioner, whether the petitioner is stated to have started abusing, misbehaving, threatening the complainant to teach her relation. This resulted in a extended relationship between the present petitioner and the complainant, whereupon the present complaint was filed by the complainant alleging that she had been sexually exploited and her life has been spoiled by the present petitioner by obtaining her consent by marriage by misrepresentation on the basis of a courted allegation, case of the rape, cheating, and bigamy was registered against the present petitioner. In this case also, the Honorable High Court granted bail. No doubt, the allegations made against the petitioner are very serious in nature, but the severity of the allegations is not the only consideration which could result in the denial for the grant of the bail to the petitioner. The totality of the circumstances deserves to be seen before a person is granted or denied anticipatory bail. The Supreme Court on so-and-so has held down that the court should be loath to reject the grant anticipatory bail inasmuch as it impinges on the personal liberty of a person, meaning thereby unless and until there is an imminent and a great imperative to have a custodial interrogation of an accused, the anticipatory bail doesn't deserve to be denied. In the instance case, assuming the allegation against petitioner to be correct, at best, the case of the consent of the complaint or contracting marriage has been obtained by fraud or misrepresentation is made out. Assuming the allegation against the petitioner to be correct, at best, a case of the consent of the complainant or contracting marriage having been obtained by fraud or misrepresentation is made out. This fact doesn't require any custodial introduction because the complainant herself has to be testified before the court as and when the petitioner is put to trial as to whether that consent was obtained by misrepresentation or fraud. There are certain judgments in which honorable courts have decided that what is the matter of the, this is the whether the consent has been obtained by misrepresentation or fraud. This is the matter of the trial. And the anticipatory bail should not be denied on this issue, that the consent has been taken by fraud or misrepresentation. The contention learned such telephone instruments are also required to be required and doesn't convince sufficient ground for denying the anticipatory bail. In this method, anticipatory bail is also granted. Another judgment we will also discuss. Quick look into the if there is a delay in the FIR, then this is one of the ground. In 2000, Bikul Bakshi was State of NCT. The parties were acquainted with each other before the incident. They were related to each other. Physical relation took place between the two on the alleged promise to marriage. The prosecution lodged FIR when allegedly the petitioner and his parents declined to solemnize. There is a delay in lodging an FIR. Then this is one of the ground, and considering the fact and circumstance, petitioner is granted anticipatory bail. So once there is a delay in the FIR and both are living together, then anticipatory bail is granted. Now we come into the regular bail. In this case, the brief facts of the case, because regular bail is only granted when there is a person is arrested, and this bail is granted under section 439 of the CRPC. The brief facts was that the complainant that the accused has been making the false promise of the marriage. This is again the false promise of the marriage, and exploiting her continuously. Complaint was lodged, and after investigation, charge sheet has been admitted. Offences has been made under so-and-so. Initially accused were granted anticipatory bail by the so-and-so, but later on it has been cancelled by the session judge, but principally on the ground that the accused had not disclosed the fact that so-and-so 2G inspection case was already going on. The order of cancellation offered by the High Court and this court. The accused then moved the application under section 439 for grant of the regular bail. The High Court has allowed the application for the grant of the bail and had directed that the accused be released on the executing the personal bond with the two COTs. In this matter, the Honorable High Court has granted the bail. Then he has approached to the Honorable Supreme Court for cancellation of the bail. Then the Honorable, this is the judgment by the Dr. D.Y. Chandrachud, the Honorable Chief Justice of India as of now. Then this appeal was dismissed. Cancellation was not granted on the ground the accused had the benefit of order granting anticipatory bail. The grant of anticipatory was cancelled principally on the ground that he has not disclosed the pendency of the prosecution case. Court has been informed during the course of the investigation that he has been acquitted. The regular bail was granted by the High Court. The second FIR which was lodged was not a supervening circumstances such nature as is warrant the cancellation of the bail, which was granted by the High Court. The accused has submitted that the lodging of the second FIR 4 days after the order of the bail was merely an attempt to bolster a case based on the supervening event, and that it suffers from the vigilance and complete absence of the default. Then the Honorable High Court has granted the bail on the following grounds. And one of the grounds that this is the High Court has granted, the High Court has allowed the application for the grant of the bail and has directed that the accused be released on the executing personal and so-and-so. And finding of the Honorable High Court also that the allegation of the complaint that the accused has promised to marry her was a matter of the trial, and whether her consent was obtained by fraud would only be established during the course of the trial. It is very established fact that whatever if there is a false pretext of the marriage, then it can be proved under trial. But on this ground, that anticipatory bail or regular bail cannot be denied. Honorable Supreme Court has declined. For the above reason, we hold that the order of the High Court allowing the application bail cannot be faulted. No supervenient circumstances have been made out to warrant the cancellation of the bail. The bail was not cancelled by the Honorable Supreme Court. This is the case of the Honorable Supreme Court. And further, we will discuss the questioning. In the same fact and circumstances, there is a case of the Raj Dulari. Hardly we will take 1 or 2 minutes, not more than that. This is the questioning. This is the case of the Honorable High Court of Delhi, decided on 30th September 2023, S. Raj Dulari versus the state. In this matter, the Honorable High Court has quashed. FIR has been quashed on this issue. Present petition filed under section 2 to quash FIR filed against petition for alleged commission of the offences punishable under so and so. Whether the impugned FIR is liable to request, living relationship agreement did not mention promise of marriage by the petitioner. No basis for the complainant to entertain notion of promise of marriage from petitioner. Complainant herself by virtue of existing marriage was ineligible. No basis of the complainant to entertain notion of the promise of marriage from the petitioner. Complainant herself by virtue of her existing marriage was ineligible to marry present petitioner. No allegation of the mischief under section so and so IPC or outrage majesty under section so and so. Nothing on record to suggest commission of the same offense. Impugned FIR quest certified petition allowed. If there is once the lady is already married with someone else, then questioning is also granted by the Honorable High Court. And another questioning petition we will discuss about the Honorable Supreme Court, that there is a clear-cut distinction between the sexual physical relationship and the rape. This is the last. That Honorable Supreme Court. This is the latest judgment of the Honorable Supreme Court 2021, Sonu versus Respondent State of Uttar Pradesh. This is the quest. Honorable High Court had declined to quash it, then the Honorable Supreme Court has quashed it. The fact is, the present installment matter was registered on the basis of the written complaint of the second respondent on the ground that second respondent developed friendship with the appellant and assured to marry her. She allegedly was exploited physically for 1.5 years, and that the second respondent had also spoken to the parents and sister of the appellant. However, later appellant backed out from his assurance. Appellant sought quashing of the proceeding of filing, which however was dismissed by the High Court by the impugnation, hence the present appeal. Then Honorable Supreme Court findings that there is a clear-cut distinctions consent of the woman with respect to something must involve an active and reasoned deliberation towards the proposed act. To establish whether the consent was vitiated by the misconception of fact arising out of the promise to marry, two presumptions must be established. The promise of marriage must have been a false promise. There should be once you are the intention has to be looked into. That at the time of the very inception, your intention was to not to marry. Once your intention was to marry at the very initial stage, then later on certain things have been developed and you are not able to marry, then it is a no false pretext of the marriage. And this Honorable Supreme Court has quashed. Then this question was allowed. There is a clear distinction between the false pretext of the marriage and rape. Allow the impugned order. Assuming the all allegations by FIR correct and purposes of considering the application questioning FIR, so no offence is established. There is no allegation to the effect that the promise to marry given to the second respondent was false at the inception. This is importance, that there is no allegation to the effect that the promise to marry given to the second respondent was false at the very inception. From the very beginning, your intention was not bad, then it is quashed. Contents of the marriage second which gave rise to the allegation of the FIR on these High Courts and error and declining so on. So this is all about, this is the question has been text this. So learner friends, this is all about from my side, because the time is, of course, the allotted time is very limited. Then we will try to cover the whatever the maximum we can do. Even though if you are having certain queries and all those things, then certainly we will have that queries and then we will finish. Yes. Is there any query? You want to discuss something? Please switch on our old videos, please. So we can also see some beautiful faces. Handsome boys and beautiful girls. Yes, please.
Yes, sir. My one query is why the court has hidden the victim identity at the time of filing the like bail or any complaint before the court.
Identity is only,
Is any specific provision given in the law?
yes, there are the certain directions has been given by the Honorable High Court and another courts, because there should identity should be not be disclosed, because it is a question of the girls that her, because she may be defamed, because even though in the some of the marriage dispute, matrimonial disputes, her identity is being not been disclosed. In the even the possessed, you will not see the name. Only because of that, no one should know which girls having the some relationship or sexual exploitations or anything else. Because it should not be the available to the general public as Miss so and so, Miss so and so is having. Because once I am reading all those judgments, once the entire public, entire world is reading these judgments, and once the name will go, certainly it will adversely affect her career, her image in the entire world. Certainly, it may be possible that no one is ready to agree to marry her. This may be the reason.
Okay,
Identity is not disclosed.
okay, thank you.
Thank you. Yes, anyone, please.
I have a hypothetical question for you. As we discussed in 375 and
धर्मेंद्र जी बोल रहे हैं?
हाँ सर।
हाँ, थोड़ा जोर से बोलिए।
सर मैं ये पूछ रहा था कि एक हाइपोथेटिकल अगर सिचुएशन लेते हैं 375 और कोर्ट अपना 6 सर्कमस्टेंस में, तो जैसे कि एज पर द इफ द बॉय इज द मुस्लिम person and if we marry with a girl which is less than or 15 years, as per Muslim law they are correct, but whether they fall in this 6th column, because exception number 2 is also given, it is only up to 15 years.
देखिए, अगर जो है मुस्लिम और हिंदू की जब बात आती है, तो जब भी शादी होती है, तो या तो अगर वो लड़की हिंदू है तो कन्वर्ट होकर मुस्लिम हो जाएगी, या लड़का हिंदू है तो वो भी कन्वर्ट हो जाएगा। जब भी शादी कराते हैं ना, जैसे मान लिया आप कोई मुस्लिम धर्म की लड़की है और वो हिंदू धर्म के लड़के से शादी कर रही है, तो मुस्लिम धर्म को कन्वर्ट करके पहले हिंदू धर्म में करेंगे, तब जाके हिंदू से शादी करेंगे।
मेरा क्वेश्चन ये है कि लड़का भी मुस्लिम है और लड़की भी मुस्लिम है।
हाँ, ठीक है,
बट लड़की की उम्र जो है वो 14 साल है। तो क्या ये 375 का 6 सर्कमस्टेंस वैलिड नहीं होगा?
अब देखिए, ये तो मुस्लिम लॉ के तहत देखना पड़ेगा कि भाई उसमें मुस्लिम लॉ के तहत उस लड़की की उम्र कितनी जो है शादी के लिए वैलिड मानी गई है।
बट सर आईपीसी को तो कॉन्ट्रावेंशन आ रहा है ना सर?
हाँ जी,
आईपीसी में तो कॉन्ट्रावेंशन आ रहा है ना सर?
तो आईपीसी में कंट्रावेंशन आ रहा है, अगर आईपीसी उनके ऊपर अप्लीकेबल है तो वो तो यही है, इसी हिसाब से ही चलेगा, वो चाहे किसी भी धर्म की है।
तो हाँ, तो बट क्या फिर मैं अगर ये सिचुएशन है तो क्या व्हाट शुड बी द आउटकम?
देखिए, अगर जो है आज की डेट में इंडिया में सबके ऊपर ये अप्लीकेबल है कि 18 साल से नीचे का कोई भी कंसेंट वैलिड नहीं है, हिंदू हो, मुस्लिम हो, क्रिश्चियन है, क्रिश्चियन है, पारसी है, जो भी हो। अगर वो लड़की 18 साल से कम की है तो उसका कंसेंट नहीं माना जाएगा और वो रेप की कैटेगरी में आएगा।
थैंक यू सर।
क्योंकि किसी भी धर्म में भी आज की डेट में भी कोई भी 18 साल से अगर कम है तो ही और शी इज नॉट इंटर इनटू द कॉन्ट्रैक्ट, और कॉन्ट्रैक्ट के लिए वैलिड नहीं है। और जो मुस्लिम मुस्लिम लॉ के हिसाब से भी अगर शादी है तो दैट इज अ कॉन्ट्रैक्ट।
सर मुझे जहाँ तक याद आ रहा है, एक जजमेंट अभी कुछ विद इन 1 ईयर पंजाब एंड हरियाणा हाई कोर्ट ने अलाउ किया था। 15 ईयर की लड़की थी, मुस्लिम मैरिज था, एंड दे विदहोल्ड की नहीं एज पर पर्सनल लॉ बिकॉज दे आर विद दैट। और उसके बाद एक उसका इसका कॉन्ट्ररी व्यू लिया था केरला हाई कोर्ट ने कि नहीं, बिकॉज पॉक्सो इज द लेटेस्ट वन एंड स्पेशलाइज्ड वन, so it will guide the personal law, and it will the judgment was the contrary to the Haryana High Court. I am not remembering the judgment actually.
चलिए
Otherwise,
कोई बात नहीं, अगर ऐसा है तो फिर हम भी देख लेंगे, फिर जब हम भी एक बार देखेंगे। वैसे तो देखिए जो आईपीसी है एप्लीकेबल टू ऑल है, उसमें कोई
definitely, sir.
हाँ, अब उसमें कोई हिंदू और मुस्लिम का जो है उसमें वो नहीं आता है।
Definitely.
हाँ, और जो एज ऑफ कॉन्ट्रैक्ट है वो भी 18 साल, वो एप्लीकेबल टू ऑल ही है, उसमें हिंदू
Sure.
मुस्लिम भी नहीं है। और कंसेंट के बारे में भी अगर 18 साल से कोई भी धर्म की लड़की हो, अगर 18 साल से कम है तो उसका कंसेंट नहीं माना जाता,
Sure.
जो अभी तक मुझे ज्ञान है। बाकी और भी कुछ डिटेल पढ़ेंगे तो फिर देखी जाएगी।
Sure.
अगर कुछ आप भी सर्च कर सकते हैं, कुछ हम भी, तो देने विल डिस्कस टुगेदर।
Sure.
अभी तक तो मैं यही जहाँ तक।
Okay.
और कोई हमारे साथी? सर नमस्कार,
नमस्कार।
बताएं
बहुत
कैसे
अच्छे,
हैं आप?
बहुत अच्छे। ये चंडीगढ़ हाईकोर्ट की बात जो कर रहे हैं ना,
हाँ।
वो अलग चीज है। चंडीगढ़ हाईकोर्ट ने ये बोला है कि सपोज ये हिंदू ने और मुस्लिम से अगर शादी किया अंडर स्पेशल मैरिज एक्ट के अंडर,
हम्म।
वो दैट कैन नॉट बी ए वैलिड मैरिज, बट इट इज इलीगल मैरिज, बट इट इज नॉट ए वैलिड मैरिज। वो अलग चीज है, वो उसके साथ कोई कर लेना देना नहीं है। But basically the assumption is the girl is, I mean, below 18 years old, then automatically POSCO will set in with whether it is a Hindu or a Muslim or a Christian, it really doesn't matter, because IPC and POXO is something totally different than the customary law.
Sir, can I comment? Actually, sir, that judgment was different. You are talking about the MP High Court judgment. This is
No.
special.
Chandigarh High Court अभी recently came out with a judgment, पता नहीं कोई शर्मा जी आया, पता नहीं कौन था, किसी ने जजमेंट दिया है, तो which specifically state अगर whether a marriage, even if it is taken under I mean registered under the special marriage, because if you are a Hindu and a Muslim, अगर आप दोनों अपना मजहब नहीं बदल के शादी नहीं करना चाहता है तो आप नेचुरली स्पेशल मैरिज एक्ट के अंडर शादी करेगा।
जी जी।
ये MP का जजमेंट है सर,
हाँ जी।
लेटेस्ट आया।
ठीक है जजमेंट, अच्छा वो फिर और कोई जजमेंट होगा।
हाँ, और मैं जो बात कर रहा
चंडीगढ़
था,
हाईकोर्ट के रिसेंटली एक हफ्ता पहले की जजमेंट है, 1 या 10 दिन की पहले की जजमेंट है, तो
हाँ
उसमें
सर,
स्पेसिफिकली बोलता है कि बिकॉज दैट मैरिज विल बी लीगल नहीं है, इट इज एन इलीगल मैरिज बोल रहा है, बट दैट इज कंजम्पशन ऑफ आई मीन the concept of the judge is wrong. I think it is wrong. Then there is no need of a, I mean, what you call special marriage act. Special marriage act is enacted for the purpose of, I mean, marrying two people with a different religion. So अगर वो कहते हैं कि भाई वो लीगल नहीं है, इलीगल मैरिज है एंड ए voidable मैरिज है, इट इज ए void मैरिज भी नहीं है, लीगल मैरिज है, बट दैट इज नॉट अ करेक्ट, आई मीन, presumption. आई थिंक वो तो अपील हो जाएगा, क्योंकि द वे द जजमेंट हैज बीन रिटन वाज रॉन्ग टोटली। दैट इज माय फीलिंग है, वो कह नहीं सकता क्या करेगा सुप्रीम कोर्ट। बट एज फार एज पॉक्सो इज कंसर्न, ए गर्ल बिलो 18 years irrespective of which religion they belong to will automatically पॉक्सो will kick in. डजंट मैटर कि वो हिंदू मैरिज के अंडर एक्ट शादी किया है या स्पेशल मैरिज में किया है या व्हाट यू कॉल मुस्लिम लॉ के अंदर, मोहम्मदन लॉ के अंदर शादी किया, दैट डजंट मैटर एट ऑल। टुडे दैट इज द पोजीशन।
सर हिंदू मुस्लिम स्पेशल मैरिज एक्ट में शादी कर सकते हैं या नहीं कर सकते हैं? ये तो
कर सकते हैं, कर सकते हैं।
मजहब से कर सकते हैं हिंदू और मुस्लिम, क्यों नहीं
हिंदू
कर सकते?
मुस्लिम और
दैट इज
मुस्लिम
द रीजन व्हाई द स्पेशल मैरिज एक्ट इज देयर।
यस सर, इट वाज ओनली
लेकिन
डाउट।
उसमें भी 18 साल से ऊपर होना चाहिए लड़की, और 21 साल से ऊपर होना चाहिए, ऐसा कुछ है ना?
बस लड़का अभी आज के दिन में तो 18-21 से लागू है, इरेस्पेक्टिव ऑफ द मैरिज, वो कोई हिंदू है, मुसलमान है, कुछ भी हो, 18 साल का मैरिज इम्पोर्टेंट है 18 साल का एज, 18 एंड 21 के एज बैंड बहुत इम्पोर्टेंट। उसके नीचे शादी करेगा तो फंसेगा। 18 साल के से 5 महीने भी नीचे आ जाएंगे तो तब भी तुम्हारे के अंदर पॉक्सो मार्क कर देंगे, अगर कंप्लेंट होता है। कंप्लेंट नहीं है तो कुछ भी नहीं होता।
18 साल से एक दिन भी नीचे रहेगा
देयर
तो
इज अ
पॉक्सो
कंप्लेंट,
मार्क होगा।
ऑटोमेटिकली पॉक्सो सेक्शन 5 सेक्शन होगा। और क्या खबर है? ऑल वेल नित्या?
ऑल वेल, ऑल वेल, ऑल वेल। थैंक यू फॉर ज्वाइनिंग।
नहीं, मैं काफी देर से था, इन एंड ऑफ एंड ऑन था, पता नहीं मैं कहीं घूम रहा था बाहर धूप में। मैं बीच बीच में आ रहा था, जा रहा था।
चलिए, एनीवन एल्स प्लीज?
क्या?
यस मिस ईसा, आप भी ज्वाइन की हुई कि नहीं?
अच्छा नित्य, एक काम और कर लो, कोई डेट पे हिंदू अनडिवाइडेड फैमिली एचयूएफ आई मीन क्रिएशन एंड डिसोल्यूशन के बारे में एक टॉपिक बना लो।
ठीक।
एचयूएफ क्रिएशन एंड डिसोल्यूशन वेरी इंपॉर्टेंट है। पीपल डजंट नो हाउ टू क्रिएट, एवरीबॉडी नोज हाउ टू क्रिएट एचयूएफ, बट नोबडी नोज हाउ टू डिसॉल्व एन एचयूएफ। वेरी
सर
लोग कहते हैं चलो हम डिसॉल्व कर देंगे, आधा पार्टीशन हाफ पार्टीशन करेंगे, हम डिसॉल्व कर देंगे। हाफ पार्टीशन इज नॉट अलाउड अंडर द इनकम टैक्स रूल्स। इनकम टैक्स रूल के अंदर हाफ पार्टीशन होता नहीं है, या फुल पार्टीशन होगा तब जाके डिसॉल्व होगा, एचयूएफ डिसॉल्व होगा। बट टेक्निकली लीगली कोई पार्टीशन एचयूएफ डिसोल्यूशन के लिए जाता ही नहीं है। सबसे बड़ी प्रॉब्लम यही है, फैमिली सेटलमेंट करके वो आपस में अंडरस्टैंडिंग करके निकल जाता है, बट दैट इज नॉट द डिसोल्यूशन।
ठीक है सर, सर्टेनली विल प्रिपेयर।
सर एक कॉमन सबको सर इशू है कि 376 में
अवेयर ऑफ द इंट्रिकेसीज ऑफ द डिसोल्यूशन ऑफ द पार्टनर।
हाँ, बोलिए बोलिए।
सर 376 में बेल के लिए जाते हैं तो क्या मजिस्ट्रेट के पास भी अप्लाई कर सकते हैं? वी कैन फाइल बेल एप्लीकेशन बिफोर मजिस्ट्रेट और नॉट?
नो नो, 437 में बेल एप्लीकेशन फाइल नहीं होगी। ये केवल 434, 38 और 439 में ही फाइल होगी। 437 में फाइल नहीं होगी क्योंकि ट्राइबल बाई मजिस्ट्रेट नहीं है। मजिस्ट्रेट की पावर ही नहीं है बेल देने की। क्योंकि जो भी केसेस है ना, देखिए 437 में वही केसेस जाते हैं जो ट्राइबल बाई मजिस्ट्रेट हैं। जी सर।
ट्रायबल बाय मजिस्ट्रेट मींस आई मीन जिसका सजा 3 साल और उससे नीचे हो।
हाँ जी।
एंड एनीथिंग आई मीन बियॉन्ड द सजा जो 3 साल प्लस है, तो दैट
हाँ।
सेशंस विल हैव टू टेक अप। देयर इज नो पावर फॉर द मजिस्ट्रेट टू आई मीन ट्राई द केस, एनीथिंग फॉर ऑल द केसेस व्हिच हैज गॉट अ सजा ऑफ मोर देन 3 years। हमेशा याद रखो कोई सेक्शन का इंग्रेडिएंट्स क्या है, वो सेक्शन में कितने वैलिडिटी है उसका सजा, मैक्सिमम सजा वो पर्टिकुलर सेक्शन में क्या है, दैट इज द मोस्ट इम्पोर्टेंट। अगर 3 साल तक है तो मजिस्ट्रेट हैज गॉट द पावर, एंड सजा मोर देन 3 years प्लस है, 3 years प्लस है, तो देन मजिस्ट्रेट विल बी एक्सक्लूडेड एंड द केस विल बी पोस्टेड बिफोर द सेशन जज। सेम थिंग हम आई मीन सिविल केसेस में वो 3 लाख का मजिस्ट्रेट के पास जाता है, 3 लाख के ऊपर एडीजे के पास
3
जाता
लाख
है,
सिविल जज
सेम
के पास जाता है,
सिचुएशन।
उसके ऊपर एडीजी के पास जाता है।
एग्जैक्टली, पेक्यूनियरी ज्यूरिडिक्शन है यहाँ पे।
437 में जो है सेशन के पास नहीं जाएंगे, सेशन के पास आप 439 में ही जाएंगे।
सर एक
हाँ बोलिए बोलिए, आपकी आवाज नहीं आ रही है।
376 में चार्जशीट फाइल होगी
हाँ।
आफ्टर कंप्लीट एफआईआर, देन सर चार्जशीट तो मजिस्ट्रेट साहब के पास ही फाइल होगी ना?
चार्जशीट फाइल मजिस्ट्रेट के पास होती है, लेकिन जैसे ही चार्जशीट फाइल हो जाती है
नहीं,
मजिस्ट्रेट का
सेशंस
काम
में
होता
फाइल होगा, केसेस एजेंट्स में
जी
है।
सर।
ना, एक मिनट। चार्जशीट जो है मजिस्ट्रेट की फाइल होती है, मजिस्ट्रेट जो है चेक करता है कि सब कुछ ओके है, चार्जशीट की कॉपी आपको सप्लाई कर दिएगा, उसके बाद वो सेशन कमिट कर देते हैं तुरंत। उनके पास डील करने की पावर नहीं है, केवल जाकर के चार्जशीट को फाइल कर देते हैं। चार्जशीट वैसे ही फाइल होगी, वैसे ही जो है एक्यूज को समन हो जाएगा कि भाई आपकी चार्जशीट फाइल ही, चार्जशीट लीजिए। जैसे ही आप वहाँ पे अपीयर होंगे तुरंत वो सेशन कमिट हो जाएगा।
तो 376 में तो एफआईआर होते से ही अरेस्ट हो जाएगा, एक्यूज तो अरेस्ट हो जाएगा।
अरे भाई, तो 376 में एफआईआर होते से अरेस्ट होगा, लेकिन अरेस्ट होने से पहले तो एंटीसिपेटरी बेल भी तो लगाएगा, वो तो भागते रहता है।
हाँ
एंटीसिपेटरी बेल तो तभी लगती है जब वो भाग रहा है।
जी सर।
ऐसा थोड़ी कि जैसे एफआईआर हुई वैसे जाके पुलिस ने तुरंत पकड़ लिया, मिल गया तो ठीक है, नहीं मिला तो क्या करेंगे?
जी सर।
ऐसा कोई
और
जादू
एक
खड़ी
चीज
नहीं।
और याद रखो, ऐसे केसों में जमानत के लिए जाओ ही मत 3 महीने के लिए, कुछ नहीं होने वाला है। 3 महीने के बाद कोर्ट में जाना जमानत के लिए,
ना
अदरवाइज
3 महीने के लिए आप जमानत
कुछ नहीं
के लिए
होने
आएंगे
वाला,
तो
तुम
बिना
लड़कते
अरेस्ट
रहोगे
90 डेज वाला एप्लीकेशन नहीं है ना भाई। बिना अरेस्ट 60 डेज 90 डेज वाला एप्लीकेशन नहीं आएगा। जब अरेस्ट होगा तभी से 90 डेज शुरू होगा।
एग्जैक्टली।
हाँ, अगर वो आप अरेस्ट है साल भर अरेस्ट मत हुई, चार्जशीट फाइल ही नहीं होगी। वो तो डिस्कशन है उसकी, कब
अरेस्ट
करेगा, लेकिन अरेस्ट होने के बाद ही 90 डेज एप्लीकेबल
एप्लीकेशन
होता है।
फाइल करना बेल की देगा
जुडिशियल रिमांड के
हाँ
बाद।
नहीं
हाँ, जुडिशियल रिमांड के बाद, जी जी जी। जुडिशियल रिमांड में 90 डेज में उसको फाइल करना ही करना है, लेकिन अगर वो अरेस्ट नहीं हुआ तो कोई नॉट मैंडेटरी कि 90 डेज में ही करना है। ये चीज हो।
तो अरेस्ट
धन्यवाद।
हो गया तो आपको 90 डेज करते तो यू कैन इवन गो फॉर ए डिफॉल्ट बेल।
यस सर, डिफॉल्ट बेल अगर 90 डेज में नहीं करते हैं डिफॉल्ट बेल मिल जाएगी। So thank you to all of you, yes, for joining and given your valuable time of 1 hour. I am so thankful to all of you. Certainly we'll get in touch. Yes, Miss Nikita.
Great.
I would
Bye,
like
see
to
you.
thank Dr. Nitin Singh for getting us aware and for sharing his valuable knowledge that would help us a lot. And thank you for this platform through Vidya Vijay Foundation. Thank you everyone for joining. Have a great day ahead. Thank you.
सभी साथियों को नमस्कार, धन्यवाद।